The long-anticipated Protection of Personal Information Act has finally been signed into law. It was signed into law in November last year, but it has not yet come into effect. There are only certain sections which have come into effect, for example, the definition section and the sections in terms of which an information regulator may be appointed and under which he may make regulations. So we are of the view that they are obviously in the process of appointing an information regulator and that such appointment is imminent. And probably once he's been appointed and the regulations have been drafted, the rest of the provisions will come into effect. Once they have come into effect, there will be a 12-month period in which responsible parties can comply with POPIA. And so in light of this, we've already started having workshops with a number of our clients to ensure that they are POPIA compliant once it comes into effect. There is a common misconception that it can only be processed with consent, but there are other grounds for justification as well. For example, you will not require the consent of the data subject if it is in the processing is in the legitimate business interests of the responsible party or where it's in the legitimate interests of the data subject. Consent is also not required if it is for the performance of a contract to which the data subject is a party. And so in the employment sphere, consent is not strictly necessary for a lot of the personal information that will be processed. For example, processing personal information for payroll purposes or for pension fund and medical aid fund, that would be justified as a performance of the contract to which the employee is a party. We do, however, recommend consent. We think it is advisable to get the consent from employees. And for that reason, we've been assisting employers with drafting personal information clauses to insert in their employment contracts. And what that does is it basically sets out the purpose for which information will be processed, and then it gives they would consent to that processing. It's also important because in terms of POPIA, you are required to give notice to data subjects that you hold personal information about them and that you process it, and also the purpose for which it is processed, as well as how long such information will be retained and to who it will be disclosed. And so that is something that we actually include in the personal information clause. But what is important to note is that in the UK, under the UK Data Protection Act, there has been some challenges to consent in an employment contract. As under POPIA, the consent has to be informed, voluntary and specific, which is similar to the position in the UK. And there the challenges have been that a blanket consent in your employment contract is not specific to each occasion under which information will be processed. So that's just something to bear in mind, that the consent in itself may not be enough, and that's why you would also rely on another justification, such as legitimate business interests. Yes, under such circumstances, obviously employers often engage third parties like payroll providers or pension funds, medical aids. And if that third party is just processing the information and they are not determining the purpose for it and the manner in which it is processed, and they're just coming strictly under the control of the employer, then they would be regarded as an operator. And that means that the operator does not need to comply with all the provisions of POPIA, but they are under an obligation to keep the information confidential and not disclose it. And they also need to ensure that they have proper security safeguards in place. It's also important that the employer, as the responsible party, has made sure that the operator has got those security safeguards in place. Right, at this stage, we are not entirely sure what all those security safeguards will be, and we envisage that the regulations may deal with this. But what POPIA does provide is that you need to ensure that personal information is protected and that it is protected from data breaches and from individuals gaining unauthorized access to it. What it does require as well is that when personal information is destroyed, it must be destroyed in such a way that it cannot be reconstructed. Yes, there is. Under POPIA, you can only transfer information to foreign countries if the data subject has consented to this transfer, or if that foreign country has similar data protection principles in place. There are certain countries in the world, like the US, for example, where the data protection principles are not recognized as being similar to the UK Data Protection Act, and presumably also to our Act, which is very similar to that. And so in such circumstances, you would then possibly require a contract with the recipient in that country, in which they undertake contractually to keep the information secure and to implement necessary security safeguards.